Standard divorce proceedings assume a valid marriage existed. However, when a relationship is built on a defective foundation, the rules change. If a marriage or civil partnership is legally defective from its inception, the court cannot dissolve it. Instead, the law must determine if it ever existed at all. This moves the case into the realm of nullity, governed by the Matrimonial Causes Act, 1973, and the Civil Partnership Act, 2004. English family law evaluates defective unions along a defined legal spectrum. A relationship will be classified as either voidable, void, or a non-marriage. This specific categorization determines whether the court has the statutory jurisdiction to issue financial and property orders. Upon separation, the financial survival of the parties depends entirely on where their union sits on this legal spectrum. The first category is the voidable marriage. A voidable marriage is legally valid until it is challenged. It possesses a specific defect that allows one party to petition for an annulment order. These defects include physical grounds, such as non-consummation in heterosexual marriages, or the presence of a sexually transmitted infection at the time of the ceremony. There are also cognitive grounds. A marriage may be voidable if valid consent was missing due to duress, mistake, or a person having an unsound mind. Finally, the law includes specific circumstances like pregnancy by a third party or an acquired gender that was not disclosed to the partner. Most applications for a nullity order based on these grounds must be presented within 3 years of the date of the marriage. Despite these defects, the law treats any children born into a voidable relationship as fully legitimate. This classification also preserves the financial rights of the parties. If a nullity order is granted, both parties maintain access to the full suite of financial and property orders under the 1973 Act. A voidable marriage provides all standard legal and financial protections unless and until a court actively annuls it. The spectrum then moves to the second category, void marriages. A void marriage is void ab initio, meaning it never existed in law due to a failure in its basic formation. Lack of capacity is a primary cause. Following the 2022 Act, any marriage where a party is under the age of 18 is automatically void. The union is also void if the parties are too closely related by blood, known as consanguinity, or by marriage, known as affinity. Existing marital status, such as bigamy or a polygamous marriage involving a UK-domiciled party, also results in a void union. While a void marriage technically never began, a formal court order is practically necessary to trigger any subsequent financial proceedings. Children of a void marriage are still treated as legitimate if at least one parent reasonably believed the ceremony was valid. In this classification, the marital status and the financial remedies diverge. Even though the marriage legally never existed, the Matrimonial Causes Act still permits the court to divide assets and order financial relief. Establishing that a marriage is void provides a statutory safety net for the vulnerable party, even when the union itself is a total legal failure. The final classification is the non-marriage, also referred to as a non-qualifying ceremony. This occurs when a ceremony fails to meet the baseline legal threshold required to even be considered a void marriage. The 2020 case of Akhtar v. Khan illustrates the impact of this categorization. The couple lived together for 18 years and raised 4 children after undergoing an Islamic nikah ceremony. However, the ceremony bypassed all civil preliminaries under the Marriage Act 1949. No formal notice was given, and no registrar was present. The Court of Appeal ruled that because of this failure, the relationship was a non-qualifying ceremony rather than a void marriage. A similar ruling was reached in Al-Gamal v. Al-Maktoum. A secret Islamic ceremony that ignored English formal requirements resulted in the dismissal of the nullity application. The consequences of this classification are absolute. Without a valid or void marriage to act as a hook, the applicant is barred from all property and financial remedies under the Matrimonial Causes Act. A non-marriage classification leaves the parties as legal strangers. Regardless of the length of the relationship, they walk away with no statutory financial protection. This matrix creates the legal ontology of defective unions. Voidable marriages require action to end, void marriages are recognized for remedies, and non-marriages offer nothing. Significant financial stakes rest on the boundary between a void marriage and a non-marriage. For practitioners, the goal is often to prove that a flawed ceremony achieved partial compliance with the marriage acts. In Assad v. Kurder, the court found that a flawed Syrian church ceremony was not so deficient that it became a non-marriage. By classifying it as void, the wife secured her access to financial remedies. This legal categorization is the single factor that determines whether assets are divided equitably or one party walks away with nothing. When the existence of a marriage is in doubt, a precise understanding of these statutory thresholds is the most critical tool for securing a client's financial future.